Now we'll discuss the 27th problem. The plaintiff was a passenger in a railway train of the defendant company. At the station where the plaintiff had to get out of the carriage, the train overshot the platform. The place was dark and there were no lamps. No warning was given that the train passed the platform. The plaintiff alighted, treating that the train stopped on the platform. The plaintiff fell heavily and was seriously injured. Is the company liable for damages? So, the facts of this problem are similar to the facts of the case that was Keshavji Ishwar versus Great Indian Peninsular Railway of the year 1907. The facts of the case were the plaintiff was a passenger in a railway train of the defendant company. The station where the plaintiff had to get out of the carriage, the train overshot the platform and the plaintiff on the implied invitation of the defendants alighted where the train stopped. The place was dark and there were no lamps. No warning was given to the plaintiff that the train had passed the platform or that special care must be taken in descending. The plaintiff fell heavily and was seriously injured. It was held that the company was liable in damages. Thus, in this problem also, the company is liable for damages. And now we'll go to the problem that is 28 number. So the problem is that A sends a wire and a letter to B, the collector of a district, alleging that C, a public servant under P, is guilty of corrupt practices. A also makes the same statement orally to a friend of his. So, as allegation is false, advice he has to his remedies against A. So, in the present case, as we found here, the complaint is against a public servant to his superior. Therefore, she, the public servant, has no remedy against A in tort, but B, the collector, can take action under IPC or CRPC for giving wrong and false information. A also made the same statement orally to his friend. Here also she has no remedy. And now we'll go to problem number 29. And it is that a police constable, seeing the door of a warehouse open after dark, and in order to see that everything was right and in the execution of his duty, entered the warehouse and injured himself by falling into an unfenced soffit inside in an action for damage by the constable against the owner of the warehouse. What are the questions that arise for consideration? Will you allow the action? So, the facts of the given problem have been similar as taken from the case of Great Central Railway Company versus Betts 1921 decided by the King's Bench. A police constable seeing the door of the defendant's warehouse open after dark, and in order to see everything was right and in execution of his duty, entered the warehouse and injured himself by falling into an unfenced soffit inside. It was held that he had no legal right to enter, being neither a licensee nor an invitee, but that even assuming as he had the defendant was under no duty to him to make the place safe for him or to warn him of the danger. Therefore, in our problem also, the action of the police constable will fail. And now we'll go to the last problem, that is problem number 30. That is, A is driving at an ordinary pace along a route. B is a pedestrian walking by the side of the road. A splash of mud from the wheel of the carriage and goes into B's eye and hit it. Has A wronged B? Give reasons. So, it is a problem that we have to discuss. Nothing is wrong of which a person of ordinary sense and temper would not complain. Courts of justice generally do not take trifling and immaterial matters into account except under peculiar circumstances, such as the trial of a right or where personal character is involved. Here, wrong is of the nature of which a person of ordinary sense and temper would not complain. Moreover, it was a pure accident while A was discharging a lawful act by lawful means and in lawful manner. Therefore, A is not liable. He has committed no wrong. So, in our upcoming videos, we'll discuss all the leading cases and all those important leading cases that we have selected as regarding those leading cases, as some of them are very important leading cases relating to the exams, as in relation to 5-year LLB or 3-year LLB, even in judicial service examinations, and regarding those leading cases we will discuss in our upcoming videos.